Well, thank you, Jason, and I'd like to think that this turnout is due to my speaking skills, but I know better than that. So I know that it is due to the topic of Ladybird Deeds, and we'll talk about why kind of their popularity has increased and what the advantages and maybe some of the disadvantages are, and we'll get into that as part of the presentation. As Jason said, my name is Scott Harvey. I'm an attorney at Parker Harvey, Traverse City. We've got 9 attorneys in our office, principally business, estate planning, and real estate law firm. I've been practicing for 14 years, grew up in Traverse City, and was fortunate enough to be able to come back here 14 years ago and now raise my own family. So. And I thank Jason for having me. It's certainly a great thing for the community and service that he's been able to facilitate and provide. And so I hope you all continue to take advantage of that. So Ladybird Deeds, as I said, I think this turnout attests to their the popularity and kind of the buzz that they've created over really the last 5 years. I would say that the first half probably of my years of practice in law, you really didn't hear too much about them, and they've really come into vogue within the last 5 or 10 years, and we'll talk about maybe some reasons for that, and as I say, some of the uses and the advantages and disadvantages of those. And we'll talk about what they are. I think there's, people hear the Ladybird Deed, but they don't really know what that means or what effect it has or what it does. We'll talk about, as I said, advantages and disadvantages of them. And there are potentially some disadvantages depending on the circumstances. And then we'll talk about tax effects, both property tax effects as well as income capital gains tax effects and even estate tax effects, and then some alternatives. And there definitely are alternatives to Ladybird Deeds, and we'll get into some of those and in what circumstances they might be applicable. So background of Ladybird Deeds. So these they're thought to be named Ladybird Deeds because Lyndon Johnson used the one to convey his property to his wife, Ladybird Johnson. That is in fact true, although Ladybird Deeds as a concept predates Lyndon Johnson by a century or more. And so these were used, not a lot, but they were used from time to time in the past. And the recent popularity and use have increased greatly, and as I say, we'll talk about kind of why that is. So what are Ladybird Deeds? You can think of them as a beneficiary designation for real estate. You can think of them similar to your IRA beneficiary designation, your 401k beneficiary designation on a life insurance policy. That means, just like a life insurance beneficiary designation, when you pass away with a Ladybird Deed, that title in that property, just like the life insurance death benefit, automatically vests in who you've named as the beneficiary, who you've granted the property to in the context of a Ladybird Deed. Technically speaking, it is an enhanced life estate, and so you as the owner of the property convey the property to a grantee, could be a son, daughter, grandson, granddaughter, spouse, you name it. And typically it's children that are named as the grantees, and then you as the grantor reserve not only a life estate in the property, and so you continue to own it and be able to use it and live there for the remainder of your life, but you also retain the power during your lifetime to convey or mortgage that property. So you can still, even with a Ladybird Deed, and this is one of the features of it, unlike a typical life estate where you grant the remainder interest to the kids and reserve a life estate for yourself, You do reserve the life estate, but you also reserve, as I say, the ability to convey it or to mortgage it during your lifetime, or gift it away, or do whatever you want with it. However, if you do own it, then at the time of your death, then, as I said, title automatically vests in who you've designated as the grantee on that deed. They just need to record your death certificate with the county. And this is done by either a quitclaim deed or a warranty deed. So there is actually a deed that is prepared and signed and recorded with the Register of Deeds in the county of the property. Talk a little bit about uses, and these really gained kind of popularity for Medicaid planning purposes, and this is kind of really where they came kind of into vogue, where you've got, you know, as Medicaid qualification, desire for qualification has expanded greatly. This is one of the tools that a Medicaid planner had used to be able to help in that qualification and continued qualification. The Ladybird Deed and transferring the property, reserving to yourself, again, a life estate and the ability to convey or mortgage the property during your lifetime. It is not considered a divestment for Medicaid purposes. So whereas if you made an outright gift of property or other assets, you've got an issue with divestment for Medicaid purposes, and I don't want to get too much in the weeds on Medicaid planning, one, because I don't do it, and two, because it's off topic, but just know that it's not a divestment for Medicaid purposes. It also retains the principal residence exclusion as a non-countable asset for Medicaid purposes. So Medicaid, and generally speaking, you can't have more than $2,000 in countable assets. A principal residence is excluded from that calculation. A Ladybird Deed, if you transferred your principal residence via Ladybird Deed, that would continue to be excluded from being a countable asset for Medicaid purposes. And then finally, and this is an advantage, no matter who you are, is that it avoids probate. And so what that does is avoids estate recovery if you're a Medicaid recipient. And so if you are a Medicaid recipient, Michigan now has what's known as estate recovery. So the state says, okay, we're going to recover from your estate, the value of your probate estate, up to an amount that we expended on your behalf under the Medicaid program. And so they're allowed by law to take that from your estate. However, if you don't have anything in your probate estate, there's nothing for the state to attach. And they can't, at least currently, they can't reach outside of the probate estate to get other assets that you might have that are distributed outside of probate, like a Ladybird Deed would be, like the property would be. Because of this and because of some other advantages that we'll talk about, the uses have really expanded now beyond Medicaid planning, and they've really become a traditional estate planning tool in a variety of contexts and for a variety of individuals and families, and can be an excellent tool now as part of an estate plan in the right circumstances. Again, it's not for everybody, and we'll talk about some of the circumstances that it may be right for, but it isn't a fit necessarily for everyone. The main advantage really of the Ladybird Deed is that it avoids probate, and it's a simple way to avoid probate. So there are other ways to avoid probate. Certainly anything with beneficiary designations like your IRA, your 401k, life insurance that we talked about earlier, those things pass directly to the beneficiaries outside of probate. Likewise, a Ladybird Deed does. And so the property that's subject to a Ladybird Deed passes outside of probate. Again, the beneficiaries of that deed, the grantees on that deed, simply need to record a death certificate with the county in order to vest title in them. A trust is another way to avoid probate, but that is not for everybody and can be more complicated. It also avoids estate recoveries. We talked about if you're a Medicaid recipient. It avoids, and we talk about probate. There are fees, there are costs that are associated with probate. It's a public process in that there are court filings that are made that are, obviously open to public record. So it's a good thing if we can avoid probate to do so. And the Ladybird Deed offers a tool that's pretty simple way to avoid probate. Just like a beneficiary designation, as I say, on your retirement account, this is a deed that you can avoid probate of your real estate, and so a good tool to use. The other advantage is that it doesn't vest any ownership rights or interest for the grantee until the death of the owner. So if I'm going to give, if I want my son to ultimately receive my real estate, but I don't want to put him on title now, then this is a great way to do it. Why would I not want to put my son on title now? Well, one, he's 12 years old, but beyond that, even if he were an adult, he could run into creditor problems. And now, as a joint owner of the property, that's available to his creditors. He could run into marital problems. And now, as with him having an ownership interest in the property, if he gets divorced, that could be part of the divorce estate and could cause issues. He could say, I could want to mortgage or sell the property, and as a joint owner, he could say, no, I don't agree to do that. And I would, as a joint owner, would need his consent to do that. The Ladybird Deed takes out all of those issues because there's no ownership interest that the grantee has until and unless I die with the property and still holding the property. And so only at that time does he vest in ownership, so I don't have to worry about, during my lifetime, about his creditors, about his spouse, about him not consenting to do something that I want to do with the property. All of that is off the table. And so when people come to me, clients come to me and say, well, can I just add my son, daughter, et cetera, on the deed to my property, or to my bank account or to any other asset that I own? I say, no, absolutely not, because of those reasons. And, we can, through a Ladybird Deed and beneficiary designations or trusts, other mechanisms to avoid probate and make sure that it gets to him or her easily, but let's not do it during lifetime and give them any rights over it. Other advantage of a Ladybird Deed, you continue to qualify if it's your principal residence, continues to qualify for principal residence tax treatment, property tax treatment, so you retain your principal residence. You also retain the cap on the property taxes. So as you may know, Proposal A in Michigan basically caps so long as you continue to be the owner of the property taxes are capped, can't increase more than the rate of inflation or 5% per year. So there's oftentimes, particularly if you've held property for a long time and that's appreciated in value quite a bit, there's oftentimes a big difference between the taxable value and the assessed value, fair market value of the property. And because of that, if you make a transfer of ownership, that cap comes off and now you're assessed, whoever you transfer it to is assessed at that fair market value as the date of the transfer. So you can get, oftentimes we've seen, particularly with lake property, 5, 10, 15 times even that the taxes will go up if a transfer of ownership occurs. Ladybird Deed does not constitute a transfer of ownership. The cap remains on at least until your death. And then when the grantor dies, as long as it goes to a qualified family member, which would be child, grandchild, there are some other exemptions there too. Even after your death, that cap would remain on so long as it's residential property and goes to, as I say, a child, grandchild, or other family member. Some disadvantages. A Ladybird deed really doesn't address issues related to the retention, management, use of the property after your death. So, I've got many clients who have family cottages, and they want to see it remain in the family. They want to provide a mechanism for that for their kids. They want to ensure that, so long as possible, it's maintained in the family, through a cottage trust or an LLC or another type of vehicle. The Ladybird deed doesn't really address that unless you're going to direct it into one of those vehicles upon your death. It basically, the kids are the grantees, and so they're going to own it as tenants in common, and they've got to figure out what to do with it. So it doesn't necessarily address those issues. Property passes outright to the grantees. So if, in the example of my son, as a 12-year-old, I don't want him obviously to have an ownership interest in this property if I were to pass away now, and so it doesn't address a situation where you've got minor beneficiaries of the property, or a death of one of the beneficiaries, and you want it to go to their children. It doesn't address those issues, so those just need to be thought about in the context of a Ladybird deed. And then third parties, sometimes banks, sometimes assessors don't fully understand Ladybird deeds, and so there's a bit, in some instances, of education that needs to occur with them. It's a relatively, as I say, even though it's an old concept, it's a relatively new phenomenon, and so sometimes there's some education that is required for third parties, including banks or assessors. Taxes, as I said, the Ladybird deed continues to qualify for the principal residence exemption. That property, assuming it's your principal residence before, if you convey that property via Ladybird deed, it continues to qualify for your principal residence exemption from property taxes. As I said, the property tax cap remains at least until your death, and then if the beneficiaries of that property are children, grandchildren, or other qualified family member, then that cap remains so long as it's residential property. The other point, from a federal tax standpoint, if I were to gift the property, let's say, I acquired property 20 years ago, and my basis in that property is $100,000, and it's now worth $1 million. Well, if I gift that property to my son during my lifetime, he takes my basis in it. So now he's got a $100,000 basis on $1 million property. If he turns around and sells that property, he's got capital gains tax to pay on $900,000. If, however, my son inherits that property from me, then he gets a step up in basis to the fair market value as of the date of my death. So if that property is worth $1 million when I die, that's now my son's basis in it. If he turns around and sells the property, he has no capital gains tax to pay. So with a Ladybird deed, the grantee, in that case my son, would receive a step up in basis to the fair market values of the date of my death. That property, the value of that property, is included in my estate. And so because of that, my son inherits it, and he receives a step up in basis to fair market value. It is included in my estate for estate tax purposes, so that $1 million is included in my estate. However, with the estate tax exemption amount being what it is today, currently approximately $5.5 million per person, and with spousal portability, essentially $11 million combined between spouses, estate taxes now affect really less than 3% of the population. So estate taxes really, for the majority of us, not an issue anymore, but certainly capital gains taxes are an issue for all of us. And so with the Ladybird deed, it's included in your estate, which is actually a good thing, because now whoever inherits it receives a step up in basis. If they turn around and sell the property, really not going to have any taxes to pay. Alternatives, and we've touched on some of these, a trust. So you could create a revocable living trust, and some of you may have that. Many of my clients have revocable living trusts. You could put the property into a trust, and any of your assets then that are part of that trust are exempt from probate. A probate court doesn't have jurisdiction over assets owned by a trust, so those would be exempt from probate. Trust isn't always necessary for everyone, depending upon your circumstances, depending upon the assets that you have. And even with a trust, some people like to have the property remain in their names during their lifetime, so they don't have to worry about when they sell or refinance the property, worry about having to do a certificate of trust and record that and everything. So they like to have it keep in their name, and they name their trust as the beneficiary of the property upon their deaths. So you can still have a Ladybird deed even with a trust in certain circumstances if you want to. Joint ownership is an alternative, and that avoids probate, and it goes directly to the joint owner of the property, assuming it's joint with rights of survivorship upon your death. We talked, however, about the joint ownership issues and the fact that if I put my son on the property now as a joint owner, it's now theoretically at least available to his creditors, available to a bankruptcy court, available to a spouse in a divorce, and I also need his consent if I want to do anything with it. LLC or other entity, we could transfer the LLC or other property to an LLC or another type of entity to hold and maintain it. And that can be applicable in certain circumstances, particularly if you want the property to continue on in the family for a period of time after your death. There are property tax considerations that play into that. Loss of principal residence for one, for property owned by an LLC. There are also property tax uncapping issues, so you need to be careful about that. And then, of course, that doesn't address the probate issue. Your ownership interest in the LLC would still be subject to probate unless you did something with it, like put it into a trust. We talked about another alternative being a gift of the property during your lifetime, and so I could gift the property to my son. But we talked about the issues that creates from a capital gains tax standpoint, that he's going to take my basis in the property. And of course, if I gift it to my son, it's now available to his creditors, to his spouse, and so you need to think about that as well. From a gift tax standpoint, it's probably not going to be an issue. The gift tax is tied to the estate tax exemption, so even though you have a $14,000 going to $15,000 next year annual exclusion that you can give to any one person, you also have a $5.5 million lifetime gift tax exemption amount. So if you wanted to make a big ticket gift of $1 million in property, you could do that. And nobody would pay gift tax on it. It would just reduce your exemption amount for estate taxes. But again, consider the issues there with regard to basis and not getting the basis step up, and the fact that you're now putting it into the hands of your son or daughter, and what are the issues that they may face that could put that asset at jeopardy. Obviously, another alternative is simply to do nothing. And so, there are a lot of people that, and we see it all the time with estates that we need to probate, that simply don't do anything. They leave it alone. Obviously, any property that you own jointly as husband and wife, the surviving spouse inherits that doesn't have to go through probate, any of that jointly owned property. But then upon the death of the surviving spouse, it would if nothing is done. So, the issue of not doing anything is, one, you've probably got probate, unless you've got a beneficiary designation attached to it, like with retirement accounts or life insurance. And two, if you really have done nothing and don't have a will either, then the property is going to pass by the laws of intestacy. There may be, and what that would mean for you if you had children, is it would go to the children. There may be, a child that you don't want to benefit from your estate. You may want to treat the children unequally. Maybe some issues around that. So, doing nothing. Certainly from my perspective, isn't a good option. You want to plan, and even if it's just to talk to somebody about, hey, here's what I've done. What do you think? Is definitely recommended, and a Ladybird deed can be a good part of that plan. Again, depending upon your circumstances.